And the third would be legislative assembly elections. It's UT with legislature, my lord. Your lordships were taken through that, my lord, except two subjects, law and order and police. Look, this is based upon the figures which we have. The terrorist initiated instances are reduced by 45.2%. I'm comparing 2018 situation with 2023 situation.
Nothing to do.
But infiltration, which was a very major problem in Jammu and Kashmir, reduced by 90.2%, 90. In law and order events, substantially the stone pelting and other events reduced by 97.2%. These are all figures relevant for the purpose of decision.
Minister, this is not for our purposes really relevant. We only want
for the purpose of when to hold the election. As on date, this is the position. That's what I am pointing out, and these are everything is on affidavit. I am not. And security persons casualty is 60 reduced by 65.9%. These are the factors, which agencies would take into consideration. But fortunately, affected the elections most were stone pelting incidents and regular call of Bandh or Hartals, means hospitals, schools, every institution where a common man is concerned. From 2018, in 2018, the stone pelting was 1767. It is nil now. Not just because of effective policing or security personnel, but because of various steps, like gainfully employing the youth, etc. They were misled by the secessionist forces, by the forces outside the country, etc. And organized bandhs, which were in 2852 instances, organized bandh, call of bandh by secessionist forces.
How many?
In 18, they were 52. Now, it is nil. Now, Lord, so far as statehood is concerned, Lord, I have already made a statement before your lordships, but that apart, the statement of the Honorable Home Minister on the floor of the House, that UT is a temporary phenomenon. We are dealing with an extremely extraordinary situation. The state will have to be infused with several things so that it becomes a state, so to say. Lord, those actions, Lord, are initiated, and Lord, I may give some, Lord, instances how it is progressing, Lord, to become a state, because I am unable to give, Lord, exact.
You can wrap up in about 2 minutes now.
I'll just, Lord, give me 2 minutes. Your lordship did not write. I'll place it on record. Lord, for the purpose of ensuring that the UT becomes complete state, Lord, as it should have been like any other states, the central sector scheme investment is 28,400 crore. The investment proposals from other than central schemes is 78,000 crores. And till date, the actual investment made is 2,153 crores. Your lordship did not write. I'll write it down and give it to your lordships. Lord, several initiatives have taken place, and as a result of which the transparency, Lord, has shown us that the projects have risen from, and these are all, Lord, statements on affidavit I have made, 9,229 in 2018, and now in 2023, it is 92,560. More and more people are participating in e-tendering and several e-initiatives, my lord. And therefore, my lord, that is also giving a boost, and the youth is gainfully employed. My lord, the peace doesn't come merely by police action. There are several schemes which are introduced, several beneficial projects which are introduced. I'm just giving a bird's eye view, my lord. And out of 53 projects under the Prime Minister Development Package, worth 58,477 crores, out of 53, 32 are completed. This is how progressively, my lord, we are proceeding to make it a complete state. But I am unable to give, my lord, my instructions are the exact time period right now about the complete statehood, while saying that union territory status is a temporary status because of the peculiar circumstances the state had passed through with repeated and consistent disturbances of decades. Well, it might take some time, and we have shown, my lord, the progress also. It was heartening for me also to note that only in 2022, January 22 to December 22, 1.88 crores tourists visited. The lordships are aware the main industry so far was tourism in Jammu and Kashmir. Now, my lord, industries are coming. And till date in 2023, 1 crore tourists. It gives employment, it generates employment in various sectors. My lord, one, there is a tourism boom. So these are the steps which are being taken by the central government, which can be taken only if there is a union territory. And I have shown the Reorganization Act. It is having all trappings of the state. But the election, the government is ready. It is for the Election Commission of India and Election Commission of the state to take the call. Out of three, which election to take place first and how. The updating of the voters list is complete. Some part is missing, but it is yet to be over. It's in the process. It would be over, my lord, in a month or so, my lord. That's what I'm told. Thereafter, my lord, they will take a call considering the overall situation. Said once.
So you'll be wondering what the Chief Justice is doing is on a phone from the court.
Yes. This is my explanation. Learning technical assistant.
Look, I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise,
But-
because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's what, Malad, in my
But that
argument
has-
on merit.
But our decision on the constitutional issue has to be on constitutional.
but Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no one. So, Mullah, let's not, my request to your lordships is, please don't enter into this arena, because we will have to counter it with all kinds of facts, Mullah, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it while
But
answering
Mullah,
on
these
merit.
facts, if they come into your lordships, Mullah, part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There his submission is that right now development work is taking place. Some stability has to be brought about. This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to.
I have no objection to
That-
that. That statement, I have no objection.
And that's how we read it.
Yes,
actually.
well, if any other fact that you bring to your lordship's notice has no bearing, because I'll have to counter
Mr.
it.
Solicitor, Mr. Attorney, we take it that what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes,
That
but
this
to
is-
answer the election and
The roadmap to
statehood
full-
query, not as a
Correct. I have
justification
no
for.
problems to that,
And Mr.
Mullah.
Sibal also fairly says that he has no difficulty about that.
But
During my
he
arguments
thinks that
on merits,
this
I
has
never
happened.
relied upon.
This cannot be an answer to the constitutional challenge.
But
let
even
me-
otherwise, it should
I
not
also,
slip
Mullah,
into your
didn't,
lordship's
rely
mind,
on
Mullah, that these are great things that are happening, Mullah, because today, the kind of drugs that are happening with the youth in Jammu Kashmir is unbelievable. But I don't want to enter into that controversy.
Can I put it like this?
The unemployment rate is enormous.
Mr. Sibal, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a constitutional
Therefore,
challenge.
once you start placing these facts and Mullah, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood. That's all, and nothing on.
This is
on
not
the-
a justification.
This is not a justification, as it cannot be from our perspective also to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will allow
constitutional
me to
grounds.
face some counterfacts to that?
May
No,
I
it's
put
not
it like this?
necessary,
Sir,
Mr.
I had intervened that stage also when you were saying, only for this reason that we wanted in a conspectus to understand when they look towards restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Malad. They say that will take some time. Your lordships will decide on that issue, Malad.
And
Decide
that's
what should be
confined to
part.
our answer, our question to Mr.
But
Solicitor.
Bunds
are very
have been
clear
reduced
on
to
this.
zero, Bunds have
Neither
been reduced to
one
zero, all
person,
that,
don't
but
mind.
with respect, I say your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional
Right.
affidavit which was sought to be filed at the inception of the record. And I don't think there's been any change in that
DPO.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity. So therefore, paraphrase it like that.
Yeah.
You don't want to put it like
And
that.
on that
Kindly
aspect,
state.
I also
on
didn't rely.
that,
Kindly
Mr.
state.
Sibal, Mr.
It's for an
Attorney and Mr.
entirely different
Solicitor,
purpose.
I think there is a broad-based understanding on both sides that the constitutional challenge has to be answered on.
Kindly
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So whether these facts come on the record, they are part of the public space and people feel what a great thing has been done by the government. Well, this creates a problem. Well, that's why I.
What's why progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
offenses
All right,
do
Mr.
not
Sibal, we
create
got the
problem.
point. We got your point. I think we have clarified it.
Yes.
That the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should enter into the.
And they have not argued equity in defense to your constitutional challenge.
That's all, Malad, that's all.
Yes.
I suppose these statements are otherwise in the public domain. In elections will
not
be
in the public domain.
And therefore,
Mr. Attorney,
public
there's a
will
lot-
consume it.
Mr. Attorney General, you're meeting the constitutional challenge on constitutional argument.
Which I
We
did.
must
but I never-
address this matter like any other constitutional
That's
matter as a
right, that's right. In the
constitutional issue
public
which we have to
domain, I can
confront.
raise a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you made, that's not part of the public space.
And that
You-
Mr.
then you
Sibal has
need-
also clarified, there can't be any
That's
objection.
internal.
We needn't labor this issue, we are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only one
yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. Well, that means the right people are in the house arrest.
5,000 people. Let's not make
Isn't it there?
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no bunds. Why? How can there be bunds when people can't even go to hospital? People could not go to hospital because of the bun. People died.
I wish.
Not a single.
Let's not go into all this.
Mr.
I
Sibal.
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I-
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
Absolutely.
a sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into this domain to try to color the mind of the judges. We've not done that. I don't know about that.
All right. Yes, Mr. Attorney.
Now, I say that the famous principle versus rules and the hard cases thesis of Dworkin. One wonders we are not in a situation like this. We're leaving, taking off from where I left day before yesterday. There's a couple of digressions I would like to probably play before a lot before I. Because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost and an understanding which develops over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, when you are trying to understand the intent and connect with the content of Article 370, you have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of desuetude, two important principles come. A disuse plus a contrary practice. I don't get into the desuetude doctrine, it's not necessary for a purpose. I don't want to flag that. So when you're trying to understand 370 in a perspective, we have all these complexities. It's not really a case of reading the text, looking at the text and the context and arriving at a meaning. We are confounded by the practice of Article 370, whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. So I left day for yesterday on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. So while we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intend to by taking stock. I just want to place 5, 6 propositions in the context of construction against absurdity. These are all gathered from books on interpretation of statutes. Because the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. And will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What was the third one you said, Mr. Attorney?
First one is
No,
an impossible result.
no, third one.
Third one, an inconvenient result. An anomalous or illogical result. An anomalous or illogical result. And the final one, I said a futile or a pointless result. All these will go into courts looking again the presumption against absurdity. So court will avoid a construction that requires a person to do that which is impossible. The doctrine of impossibility is contracted is different, but when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. I referred briefly the other day about this presidential poll judgment of your lordships. That is 1974 to SCC 33. Before I take a lordship that 1974, it is a 143 reference in the context of holding elections. Before I take a lordship with that, let me make a few observations. It's not part of the PDF because it's not part of the compilation.
But they are reading all the time. Yes.
So we are trying to look at the proviso to clause 3 of Article 370.
So which is the part of this judgment you want us to see? Para?
I'll give the paragraphs, Your Lordship.
We have it opened up and you have it on the screen
Yeah,
as well. sir.
we have paragraphs. I'll just summarize the proposition was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the electoral college was incomplete. So the argument was, without the electoral college becoming complete, you can't hold a presidential election. Court says they read Articles 55, 54, etc., and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Therefore, the lack of the electoral college not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the electoral college completed before you hold the elections. Therefore, the
So
mandate
you're
of holding the
trying
election.
You're stretching that to our case because according to you, the conditions for the application of the proviso to Article 373 are absent. And therefore, the substantive part cannot be rendered into disuse merely because of the absence of a constituent assembly.
Therefore, I come to the arguments on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us a small para so we are then done with this judgment.
These paragraphs 4, 5, 12, 13, 15, 20, 21, 29, and 47. So there they look at the impossibility of performance.
How
So
do they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. You'll also just see paragraph 4 and 5. Paragraph 4 at page 47 of the running page 47 of the judgment. So they come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then,
Actually, the
paragraph 15, that's important for our purposes.
Some of this suggests. So let's take it to
Page 49, running page 49 of the judgment, paragraph 14 last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. No, just a scholar got that paragraph.
Only 26 pages.
Stop you from. Strike all that.
Paragraph 14, last sentence. The sentence beginning, the necessity for completing the election.
14.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentia excusat legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentia excusat legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentia excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
Say it's like an.
Yes.
29. Paragraph 21. And an argument that it shall not be done is available in paragraph 21. Your Lordship, paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assemblies of States. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assemblies of States to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered, and kindly turn to paragraph 29. Again, it was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state will deny such a right, it will be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso of Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55 read with 368 would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have an elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Karake Supra, there are vacancies in the electoral college by reason of the fact that there are no elected members of the legislative assembly of the state where the legislative assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term for the office of the president could be held only after the election legislative assembly of the states where the legislative assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is that page 57, landing page 57 of judgment.
Yes, yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more thorough way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? So one possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. So there are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. Give the reference. Yes. Video page. And then we have a key in Article 356, 1B, where after a presidential proclamation, the president can declare that the powers of the legislature it doesn't say the legislative function. So he talks about a compendium of powers available to the legislature, and that the president takes over to hand over to the parliament. Now, for the sequence of events which is contemplated in a situation like this, where there is a void,
So non-legislative.
there is an impossibility of complying with the proviso to clause 3. And how do I fill that void, if at all it's a void? I said the president could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the president does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. And once it is the non-legislative power of the legislative assembly, under 356 1B, the parliament can certainly say, I take stock of what I can do. And the parliament recommends to the president, which then we see at CO 273. So therefore, there is a sequence in which president addresses, having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all these imponderables enter into the decision-making process by the president. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You may still find a hole in that. That's a different matter. That's how the sequence of events have taken place. So I don't find, therefore, if the doctrine of impossibility stars one on the face, you are not paralyzed. So clause, since Article 370, the author, sometimes I wonder poor Gopal Samayanga, we keep talking about his statements in the Constituent Assembly. We have traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 was undergoing a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, We have counsel for the petition saying we are reasonable authors of the text of Article 370. So on the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding in construction. On the other side, we are the reasonable authors of what we'll say about Article 370. Well, two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go because after 1957, it can't serve any purpose. So this conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So that's why I say the president is not precluded from taking stock of all this. It's not merely writing on a clean slate now. I mean, one has to take stock of what has happened over a period of time. You may have so many choices of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken under Article 3 the view of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 has been taken in this manner. That's why I started saying about Lincoln, I quote from an entirely different perspective. It's not about end justifying the means. It's about taking stock of a very complex situation. Do we have a mathematical formula to do it? Or do you only measure it by saying there are constitutional mandates? If you disobey them, you breach them, then you can't follow any portion as regards Article 370? Or look at the future of J&K. I do not know whether these questions can be answered on any normative mathematical position through a judicial scrutiny and then weighed on various fine golden scales. Very difficult. So when Keshavananda Bharati has told us now, look here, don't breach fundamental features of the Constitution. Now it's become an integral part of our understanding of the Constitution. Therefore, we are told to go forward, say how the salient features of the Constitution and its functioning and exercise do not permit any deviations. Fair enough. But you look at the entire Part 18 of the Constitution, 352 onwards. And 352 occupies a very important place in the constellation of Part 18. External aggression, internal disturbance. So how do we have a mathematical yardstick or a criteria to say, this is how you will do it in the context of external aggression. This is how you will do it in the context of internal disturbance. You will have some fair, broad standards where fundamental values are not breached. But if there is something which you have to negotiate, even with the breach of some fundamental values, what do you do? Is it a political question or is it a pure judicial question to be answered in the basis of textual reading of the Constitution? I mean, that's what is confronting the court. But we are trying to assist the court in saying that you come as close as possible certain meanings which will advance the course of justice and understanding the scheme of Article 370. So this maxim, impotentia excusa legum, has been applied in large number of circumstances in the field of contracts, in the field of legislations, so on and so forth. I'll give a few illustrations later after I then may take your lordships to go beyond this judgment. Take me to submission. P70. A few minutes. we have a mass of
What else? What more now, Mr. Attorney?
I may request Lordships to come to my written submissions and that's volume 4. I just want to place a few comments at this point of time.
What would be the PDF page?
Yeah. Volume 4. There's a separate volume.
Yes.
Internal
What
submission,
page?
separate
You
volume.
were
Yes,
read up to a
page,
point, so.
PDF page 26. Couple of paragraphs from the submissions. I just want to make a small
Page 26.
observation that in the context of what I was trying to communicate to the court, one looks at all those statements from Keshavananda onwards, for my in the 1977 resolution case. The justiciability of the decision-making process. President or no president does not make a difference. If the justiciability will enter in the decision-making process. They were all cases of dissolutions of assemblies. A very narrow question of a dissolution of an assembly. But here we went in a larger canvas. Lordship, please.
You're referring to the standstill agreement or something, because that is what page 26 is about.
Which is the para that you're referring to, Mr. Attorney?
Yes.
Because page 26, we have, the standstill agreement, as Justice Call said.
Yeah, page 26. I think it should be page 27. It begins at page 27. PDF page 27.
Idea of Article 370, its relevance and scope.
That's right, that's right.
Let's read through it. Let's see. Yes, we got
PDF
it.
page 27. So before I try to convey this, that you try to invoke the jurisprudence of Bommai in a context like this, that could be a problem. As I said, there is a context of the resolution of an assembly. What factors go into it, whether they are relevant, objectively scrutinizable or not. But we are, as I said, in a larger canvas of taking a decision which has not only an importance for the purpose of looking at a part of the constitution to serve a certain purpose over a period of time, but looking at the future. So in all those cases, you're looking at an event which had a limited impact at a given point of time. We are looking at events which will have far-reaching importance forever in the future. Therefore, anything which is said in Bommai as conclusive in regard to judicial review, sovereignty, etc., I think may not be opposite. Let me not be taken to be understood that merely because there is too many complexities involved, the importance of the decision to be taken, and the impossibility dimension, etc., certain fundamental mandatory requirements of the Constitution can be slighted. I'm not proposing that at all. But we are trying to find out if, without slighting them, if there is a way that has been adopted, or if it's not been fundamentally breached, irreversibly breached. I'll come to that argument a little later. Therefore, the court will look at it very differently. So let me try to read a few paragraphs of my submissions here in 370. I have been trying to say this, that in paragraph 3, Article 370 envisaged a scheme of constitutional integration of the state of J&K with the Union of India, and thereby establish an interim system for the governance and administration of the state of J&K unit. A complete integration was achieved as was done in respect of other states. That's why much labor was taken by learned solicitor to tell your lordships. Look at the long history of what happened in the rest of the country. They all went through, many of them went through the process of constitutional ideas, constituent assemblies, a draft constitution, then comes Bion Rao's committee on a model constitution. So all that has been gone through in the rest of the country. So it is nothing new which has happened here. Only thing is having regard to the situation obtaining then, the external issues. The parliament thought, let us tide over it. How do you tide over it? We need a mechanism to tide over it. And we also probably inject into it a constitutional integration thought. That constitutional integration thought as the three aspects of 370, as I told you last yesterday, that I have set out in paragraph in the running sequence under the same page 30, paragraph 9, the three dimensions of Article 370. So except the third dimension, namely termination, the other two dimensions have deep relevance to the constitution making process, constitutional integration process. So how will Parliament come and legislate before the Constituent Assembly takes a final call on what kind of a constitution we will have or a document we will have? So to enable Parliament to come in and legislate during that period, and once that is done, which has now become a permanent feature of the Constitution. So constitution making process was there in we have in Article 371 and 2 subclause B. So the other part is you extend the provisions of the Constitution. That's an equally important part of constitution making process. So once you extend the provisions of the Constitution, then what remains thereafter? So final constitutional understanding of what framework a Constituent Assembly will arrive at has to be aided and assisted by this process. Importantly, a fair element was drawn in, consultation and concurrence. We're not to the point whether it's Sadri Riyazat, a governor, later prime minister, all those things are probably irrelevant. You're looking at the substance, not the form. If these are the three dimensions of Article 370, I would very respectfully say the termination of the role of Article 370, it could have happened any time. It could have happened soon after 1957. It could have happened even after when Article 35 was introduced and somebody could challenge is what is happening in Article 370. Now that it has happened at some point of time, and the termination has to be brought about in a particular way, which is the best and the most suitable way the president thought in the given circumstances. That's why I said taking stock to be an effective way of bringing it to a closure. I can't imagine anything out of thin air. I have to find out the best way available within the framework of the Constitution and the precedents available to the President, where Article 371D have been invoked, substitutions have been made. That's why I'm on pains to point out that when you talk of substitution of a Constituent Assembly by Legislative Assembly, we are looking at the non-legislative functions of the legislature as well as the Constituent Assembly. If the Constituent Assembly had recommended to the President before 1957, it would have done the same job. So if it could be done by any other equally competent body, now today first steps in the Legislative Assembly, and because there is a President rule, the Parliament steps in. To say that the Parliament is of a lesser paramount character than the Constituent Assembly in taking decisions for the nation's future. So, therefore, there is a weighing or a balancing may have to be a very, very difficult job. But my submission is, so the termination of Article 370 must occur at some time, notwithstanding whatever has happened over a period. And if the termination can occur in more than one way, whichever is the way which will advance the larger interests. That's why you look at the firmament of Chapter 18, Part 18 of the Constitution. I yesterday read out few parts of Chevrol's judgment to show that the president, the exercise of power of the president is legislative and not executive. The governor's powers under the 5th schedule, powers under the 6th schedule to extend a parliamentary law to the 5th schedule area has been said to be a legislative exercise. So modification has been considered with several judgments to say it's a very wide amplitude. It's as good as sitting in judgment over the parliamentary legislation or the constitution. President is given that power to extend the constitutional provision with modifications, with that supreme authority given to the president. Yesterday I pointed out at page, PDF page 33, that's part of Chevrol's judgment. The middle of that paragraph, where it says, Your Lordships have that page of my. The one sentence, application conforms to this. That's right. That's right. I just want to. Then let me take your Lordships to few aspects of the recommendation. It's only to throw some light on that. Paragraph 12 at page 36. You can pick up any dictionary or any precedent on this question of nature of recommendation. There are a large number of provisions in the Constitution of India which uses the word expression recommendation. The context would be important. Sometimes it's a recommendation which can't be simply ignored or disregarded. Sometimes it can be binding. But by and large, the recommendation concept is to advise, to commend for action. All that few illustrations I have set out here in paragraph 12, I don't trouble your Lordships with reading. I just only conclude this part of the argument by inviting Lord's attention to paragraph 18 of the submission that page, internal page 38. Either the legislature of the state nor any resident of the state has any independent right in the continued retention of Article 370. In other words, beyond the constitutional integration process visualized to be completed, there was no other purpose of Article 370. As such, no person could claim the right of permanent retention of Article 370 as a permanent integration process. And the concluding observations are in paragraph 21, begins at page 39 and ends at page 40. And the last few sentences here, running to this page number 40 of the PDF. And that's right.
Let's read your conclusion, Mr.
That's
Atkinson, how you sort of sum it up.
Therefore, we are told that Article 370, by reason of its exercise over a period of time, she is now open to several interpretations. And there's only one solitary interpretation, that it is to aid in the constitutional integration process. Whatever has happened even thereafter will have to be seen in the light of that. If anything has, by way of deviation occurred, well, it is open to correction by the president. So that's precisely what's happened now. The president says, I started saying, the president is not precluded from taking stock. The taking stock is inherent in Article 370. So if there is anything intrinsically which forbids the president to take stock of Article 370 and its exercise over a period of time, then one can understand it. But I don't think anything is available there. So therefore, I think it will open to the president to take stock of all the exercise undertaken under Article 370 and take into account the larger considerations which loom large before the nation, particularly the state of the case.
Yes, Mr. Anything else, Mr. Attorney? Now?
Your Worship. So we are confronted with just shifted the page. This part of it. Page. I'm sorry, navigating the system.
We are also navigating the time constraints, Mr. Attorney, now. So I think we can wrap up now, Mr. Attorney. If something remains, you can tell us after lunch if there's some thought which escaped your mind or something.
I would have done it very briefly now.
Yes.
I had a shared with the court. There's some document I wanted to share with the court. I think it's missed getting into the court system.
Mr. Attorney, why don't we do this? We'll call upon the next counsel. You can come back to us after lunch if you're junior and you can
I'll
spend it
do
at
it.
lunch. We'll give you 2 minutes. There's no difficulty. So if there's some important thought that you have missed, we'll certainly not stand on the formality of concluded the argument. We'll let you again. So if there's something which remains, you can tell us in a minute after lunch, Mr. Attorney General.
Very well.
Thank you, Mr. Attorney. Mr. Sarve will be arguing
Yes.
after this. Yes,
may I
Mr.
have
Sarve.
Short submission, ma'am.
to make, before I come back on that. In my prepared I thought we wanted to share a 2-page note with your lordship, but I think it didn't get into the system. Let me do it.
There's some thought which remains. You can come back after lunch. No difficulty.
Very well.
Thank you, Mr. Attorney General.
Very well.
Thank you. Yes, Mr. Sarve.
Yes.
I have a few okay, then I'll come back after.
Yes,
after
certainly.
lunch.
There's something, a point here or there which has been missed out. You can
Yes,
tell us.
I'll
We'll add
continue
it.
that
We'll add it.
because there are a few observations I want to make on certain aspects. So can I continue thereafter? Yes.
Yes. Yes, Mr. Sarve.
Yes. My lord, I don't want, your lordship has heard this matter from both sides at considerable length. And the solicitor has, in great detail and with his customary meticulousness, ticked all the boxes and covered all the points from our point of view.
Appearing for in this matter, for the sake of the record, we must make a.
Yes, I'm appearing on behalf of the applicant in IA 9573 of 2020 in petition 1099 of 2019. I have, my lord, for your lordship's convenience, made a 3-page roadmap of what I'm going to submit, if your lordships permit me to hand it over, so that it will be easier just instead of your lordship noting down.
Yes, Mr. Saleh.
Yes.
Has it been given to the court master already?
I believe so, Manoj. Mr. Agarwal from. It has been sent, I believe, Manoj.
अभी भेजने यार. He'll just display it for everybody because that way the other side also knows what your arguments
Yes,
are. So therefore we take it as just an aid memo, nothing more.
It's like a skeleton of submission.
All right.
It just sets out the points which I'm going to address, not what I'm going to say.
Just give us a moment, it will be uploaded so that
Yeah,
that way
not surprised.
your learned friends on the other side also simultaneously
course.
can see what we have. Shankar Narayan, you can tell Mr. Dhawan and Mr. Jha. They'll get it on the main screen as well. But I'm sure the main screen will also have it for.
Without interrupting my learned friend, I just want to, there's some part which is missing in our, I try to upload it I can share with the lordships. Right.
Yes, Mr. Sarve?
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issue. One is the construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, I don't think I mean, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power, it's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. Very short submission in each of these headings. The first point, my lord, relates to the construction of the proviso. Your lordship have heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. So normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have, my lord, and the solicitor read it out to your lordship. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then, my lord, Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does. And its words have to be given their plain meaning. So, my lord, the first thing your lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance in this point has been put. If the idea was that the president could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the president may. And your lord, in fact, in the course of the hearing, my lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my lord, of that kind is 249. Courts are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a precondition for the exercise of power.
But Mr. Salve,
Yes.
does the proviso to Article 370(3) does not bring about the same result
Yes.
by the use of the expression shall be necessary?
Yes. So, my lord, shall be necessary here must then be subject to the principle that if there is a Constituent Assembly, then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a Constituent Assembly, then you cannot act in vacuo. That was, in my respectful submission, the textually, because my lord, we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the president to act, my lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Secondly, my lord, this very article, and we have all this is textual. This very article uses two separate expressions. B2 uses the word concurrence. I mean, it's a point which has been already made. And the proviso uses recommendation. Now, if, my lord, one had put concurrence here, the argument would still remain, but it would have been a much stronger place for the Constituent Assembly. So while, my lord, distribution of the fields of legislation in subarticle B of, in clause B of subarticle 1 was put as concurrence of the government of the state. At the same time, subarticle 3 used the word recommendation. It's not an amendment, it's not this. So, my lord, one must assume, and this was a article which had internal dissensions and differences, and it was very carefully crafted between the within the committee and within the assembly. There were differing points of view. So, my lord, we must give meaning to every word of this article. So the difference between concurrence and recommendation and its framing as a proviso. At two places, again, subarticle 2 says, if the concurrence. So, my lord, this is the very conscious departure from the concurrence, recommendation, consultation, recommendation, concurrence. One would perhaps say the difference is, if you fail to consult, it is not fatal. If you fail to obtain a recommendation, if a recommendation is necessary, it is of more serious consequence. Would it be fatal? I don't know. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
So, Mr. Sarve, there is one countervailing consideration
Yes,
which we
yes.
possibly may have to bear in mind,
Yes.
that where a change in the distribution of legislative power was envisaged,
Yes.
the provisions spoke of concurrence,
Yes.
except in the area which was covered by the instrument of accession.
Yes, ma'am.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status.
Correct, ma'am.
Abrogation of 370.
Yes.
In which case, all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted.
Yes.
Including the concurrence on the distribution of legislative
Yes,
power,
yes.
consultation.
Yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution, but for abrogating the article itself, nothing more than a mere recommendation is required?
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the
Once the
contextual.
power under the proviso is exercised,
Yes.
then there is no limitation at all.
Absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the seventh schedule in absolute terms. And you need a very elaborate mechanism to tinker with those seventh schedule. It has to be with 50% states voting, etc. Your Lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant, the problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370. The purpose of 370 was not to create a permanent divide in the constitution. Lots of material has been shown to your Lordship on this. It was a phased integration. I'm going to deal, Manoj. Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, Manoj, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your Lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And the Lordship has seen all the material. So, border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the
Yes.
historical background or the plain text?
Yeah, the context is that this read by itself, forget the history, this read by itself shows that in subarticle 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot, saying doesn't matter, things will settle down, don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was, my lord, first recognized by your lordship in the Makbul Damnu case, which has been cited. The challenge brought where Mr. Garg argued that without the Sadr Riyasat, you could not have the preventive detention law. And your lordship said state means state as exists from time to time. That is, my lord, already there. I'll give your lordship the passage 72-1 Supreme Court cases 536.
You have given us para 28.
It's there, my lord. It's volume 1 CLC
and
PDF
you said para
36.
28 there.
Para 28. So this was already one example of how this evolved. And that, my lord, backs in with a principle of construction. Your lord, the attorney just cited the presidential reference case, which says, well, if there is a requirement, then if there is a constituent assembly, you must get the recommendation. But if there is no constituent assembly, are you denuded of the power? And the presidential reference, the attorney just gave your lordships a moment ago, the judgment based on a passage on impossibility. And your lordship cited with approval Craze on legislation, the 6th edition, in the presidential reference. The attorney just gave it, madam. The
Yes.
attorney just cited it. I have, my lord, for your lordship's assistance, given the 9th edition of Craze. I believe it's attached to my submissions. There's some slight interesting change in the text, madam. I believe it is at PDF page 37.
Mr. Salve, which is your compilation of it?
My lord, I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is, my lord, from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Zari?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses, where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which, derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, my lord, the principle is very interesting. In fact, we have used it in a different branch, Malon. In service law, for example, we've used it all the time. It says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. Then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, my lord, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old section 80J rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide, and that you can't operate unless there are rules. So we have had these two formats, and that is why we come back to why did the framers of the Constitution not say that if the president receives a recommendation from the Constituent Assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation, otherwise. Now, my lord, this was also made.
Just 1 minute.
I'm sorry.
Mr. Salve? I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
Now, my lord.
Yes, Mr. Salve.
Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the present by order specifies. So, power to the president to apply or disapply provisions of the constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't.
Yes. If your lordship sees 372(1)(b), 1 is the spread, my lord, of the list. Small subclauses 1 and 2 is this.
Corresponding to the IOA.
Yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates
B2
to.
requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred to shall be in the concurrence of the government. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the Constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. May I just restate the point now? Clause D relates to not 370, but other provisions of the Constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the President considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, my lord? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe.
I'll repeat it, my lord.
Yeah, if you could.
Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work, to try and find this area of accommodating both.
That's
So if I,
Mr. Salve, we got your point.
Yeah,
That
that's
after all, this is a proviso.
yes,
It uses the word recommendation, and it does
Yes.
say if there is a recommendation. We got that
Yes.
point. We got that line of argument.
I was just closing it by saying,
You're making just a little while ago
yes,
was that you began by saying that B1
yes,
requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
yes,
D says, subject to such exceptions and modifications as the President may order by order specify.
yes,
There also there is a bifurcation.
yes,
Matters which refer to the instrument of accession require consultation. Other matters, other than those governed by the instrument of accession, require concurrence.
Correct. Now, the point which I was making, perhaps
That's
that
the
got
point which
lost.
we wanted you to just come back
Yes.
to again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Convenience.
Why this dichotomy in the first and second proviso, my lord? Your lordship would have to reflect over. And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
Yes.
clause B of 370, 371B
Yes.
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the president, the power of parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of parliament to make the law. There's no power to make exceptions or modifications in clause B at all.
No.
And
Not at all.
bifurcate, you correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because
Yes.
these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation with the state government was required,
Yes.
because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and, my lord,
Now, when it comes to
yes.
D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a constituent assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same, is on the same
Philosophy.
trend, or is the same platform
Yes.
as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord.
Power
The
under
underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president instead of driving one to Article 368. They reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive president is executive government, where the executive government can disapply a provision of the constitution.
The only internal problem with that argument, Mr. Salve, we'll reflect on
Yes.
it during the research in the
Yes.
next hour,
Yes.
that where the power to do something lesser in terms of constitutional impact is hedged in with restrictions, namely the power to make exceptions and modifications, can we subsume that the power to have something greater, which has
Yes.
greater constitutional impact, namely the abrogation itself, will be bereft of all limitations?
My lord, to which my respectful response is, there is a compromise. I keep in my control, because the accession is complete. So what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power.
Mrs. Harvey, we are almost at the anvil of lunch. Just
Yes.
one, maybe one of the juniors can do it here in the court as well.
Yes.
Found which were those matters governed by B1 and which were the matters governed by B2. B1 basically covered the 3 subjects.
Yes.
Now, which were the matters in the IOA to which the first proviso to D applies?
We'll not try and respond to that at 2 p.m.
So
I see that.
that will give us some insight on what was the intent.
Yes. I'm deeply obliged. We'll do that.
So many articles that deal with defense, which are covered by the instrument of accession.
Yes, my lord,
And that list is given.
So I had in my list of dates, Lordships would recall the sub-article A1 says that the president would demarcate which entries fall within those 3 areas. So there was a specific order passed, possibly the first order.
48 or 54.
Yes, my lord, which 50, my lord,
50.
which said, because communication would have telecommunication, postal communication, etc., etc. So 3
So
entries.
which were the other articles?
No, we'll respond to that at 2.
Because D, the first proviso to D for Delhi, deals with other articles, not the specification of matters in the list. Not D1, the first proviso to clause D deals with other matters which are governed by the instrument of accession, where again consultation only is required. We're just sort of understanding Mr. Salve's.
Communications is also in the list. That is also not other articles.
No, I don't think Mr. Sibal has understood. My lord, I followed your lordship's
Also in the
question.
list,
I'll respond to it too.
We'll also try.
That may have some bearing, Mr. Salve.
Yes, of course.
Which one is also in the list?